Suppose a cricket match is going on and batsman gets injured by the ball which is thrown by bowler. In this case, batsman cannot sue cricket authorities or cannot file a suit against cricket authorities for the injury because when he agreed to play cricket with other team, he consented for occasional injury which might happen while playing cricket. Second case, A goes to doctors for his kidney operation. Doctors make him sign a form on which it is clearly written that major blood loss might happen during the surgery. A signs the form. It means he consented for such type of harm which might happen during operation. During the surgery or operation, major blood loss happens to A. Now over here, A cannot sue doctors for that blood loss because he already agreed for such type of situation, and this is nothing but volenti non-fit injuria. If there is a question on this maxim volenti non-fit injuria, you are supposed to write your answer in some points. So what are the points? We'll start with introduction, then meaning of the maxim, essential elements which are necessary to make a case for volenti non-fit injuria, application or in which cases this maxim is applied. Next point is different case laws which are there, and then we will conclude. So let us begin with introduction. In law of torts, there are various maxims provided. Damnum sine injuria sine damnum, ubi jus ibi remedium, volenti non-fit injuria. These maxims, they have a common law origin. So while writing introduction, write everything which I'm talking about, okay? So listen this lecture for multiple times and try to provide your answer in a pattern provided me so as you will score more, okay? So in torts, there are various maxims. These maxims have their origin in common law, okay? Common law is nothing but a British law which is followed in US, UK, USA, Canada and some other countries. Now, there are several maxims. These maxims, they have Roman origin and they are expressed in Latin language, okay? So write everything about in introduction. Then this maxim is invented by Roman Justice Eulapian. So Roman Justice Eulapian, he coined the maxim for the first time, volenti non-fit injuria. Next. So what is the meaning of volenti non-fit injuria? Listen carefully. When a person consent, okay, when person agrees for the infliction of harm upon himself, okay, when a person agrees that while playing this game, if some harm happens to me, I'm okay with the harm, then in that case, you cannot file a suit under law of torts. Example, you and your friend are going in a car. You know that your friend has taken some alcohol and he is a drunken one, okay? You know the fact and you still sit in his car. While going home, accident happens. In this case, you already know the fact that your friend has taken alcohol and still you sat in his car, and over here you voluntarily agreed for it, right? And that's why you cannot sue your friend under law of torts, because you voluntarily agreed for the harm which might happen to you. Let us go to second point in our discussion, and that is meaning of the maxim volenti non-fit injuria. To a willing person, it is not a wrong. Okay, to a willing person, it is not a wrong. Example, you are entering in a house and at the entrance a board is written, please enter at your risk and be aware of dogs. Okay, still you try to enter in that house and a dog comes out and attacks on you. In this case, you agreed to the condition, right, that harm might happen to you because there was a warning written in front of the house. Enter at your risk and be aware of dogs. And still you enter that house. It means you know that harm might happen to you. In this case, this maxim is applicable that you cannot get any compensation from the dog owner because you agreed to the terms of entering the house. Okay. So a person who knowingly, okay, knowingly, with knowledge and voluntarily means with free consent, with free will, a person who knowingly and voluntarily risks danger cannot recover for any resulting injury. A person who knowingly and voluntarily, okay, knowingly and voluntarily, these are two important terms. Knowingly means with knowledge of the fact, and voluntarily means with free will. Okay, when a person who knowingly and voluntarily risks danger cannot recover for any resulting injury. Suppose you go for scuba diving. While going for scuba diving, they make you write a form that a fish might attack on you while doing scuba diving. Okay, you sign the contract and you enter in the water, and a big fish comes and attacks on you and you get injured. In this case, you cannot sue the authorities which are there for scuba diving for this act, because you agreed, you signed on that form that injury might happen to you because of some fish in the sea. So in this case, you took the risk knowingly and voluntarily, right? You wanted to do scuba diving, and that's why you signed the form and you went inside the sea. So in this case, you are the one who is responsible, and this is called volenti non-fit injuria. Means you voluntarily entered into a contract and you cannot sue the other party under it, right? And this is nothing but volenti non-fit injuria. You are not fit to get any damage because you voluntarily and knowingly consented for a harm which might happen to you. It's little bit sunny today, so sunlight is coming on my face and some part of the whiteboard, so please excuse me for that. I'm trying to provide appropriate explanation for every case law. Okay. Let us see the next point or third point in our discussion. What are the essential elements or ingredients? Number 1, risk must be known to the plaintiff. Plaintiff must have an idea about the risk which is involved in that act. For example, your friend is going to a mechanic shop on a bike because the brakes are failed and he is going on a really low speed. You know that the brakes are not working and still you sit behind him and you met with an accident. In this case, you know the facts that brakes are not working and still you sat on the bike. In this case, your friend is not liable to pay you any compensation or damages. Next point, voluntarily agrees. A person voluntarily agrees for that. For example, scuba diving. You signed a form. Second example, when you go to see a cricket match, okay, a ball might come towards you and might give you some injury or might inflict some injury upon you. Still you go and watch a cricket match. So you know that there is some percentage of danger which might happen. Still you voluntarily go to watch the match. In this case, cricket authorities are not liable. Next, consent must be free. Okay, so over here, if someone threatens you to enter into an act, then in that case, volenti non-fit injuria is not applicable because the consent must be free. So 3 essential ingredients are very important. Number 1, risk must be known. Second, voluntarily agreed. And third, consent must be free. So what are the elements which are necessary for free consent? When consent will be called as a free consent, there is no fraud, no consent to do an illegal act, okay, and consent can be expressed or implied by words spoken or by doing some act. Consent can be taken. Okay, so these are the essential conditions which are necessary to constitute a maxim volenti non-fit injuria. Remember one thing, while writing your answer, you can provide case laws and you can provide illustrations in the form of A and B. Like I gave you so many examples, doctor and patient, cricket match, right? A friend sitting behind a friend on bike when brakes are not working. So all these types of cases you can provide in your exam. Okay, these are called illustrations. Okay, so illustrations plus case laws make a perfect answer. Now let us understand this maxim with help of various case laws. Case law number 1, Hall versus Brooklands Auto Racing Club. Name of the case law is Hall versus Brooklands Auto Racing Club. A car race was going on, okay, and accidentally one car hits the other car. Because of the collision, the car changed its path and it went into spectators and injured plaintiff. So understand what happened. A car race was going on. Okay, people, they were there sitting and watching the car race. During car race, two cars collided against each other, and due to the collision, one of the car changed its path and went into spectators and injured plaintiff. In this case, plaintiff cannot sue the auto racing club for the injury, because when he entered to see a match, he already agreed that some injury might happen to him in case some accident happens. So in this case, Volenti non-fit injuria is applicable. Second case law is Indian. Remember, in law of torts and in contract, there are lots of English case laws and Indian case laws. We still follow those English case laws, and that's why you can validly provided them while writing your answer. So second case law is Indian, and it is Padmavati versus Duganika. In this case, what happened? There was a jeep driver who was trying to fill a petrol in his jeep at the petrol pump. Two strangers came there and he asked for a lift from the jeep driver. Jeep driver said that yes, please sit in my jeep, I can give you a lift. Okay, so they requested for a jeep and jeep driver gave them a lift. While driving a jeep, suddenly the front wheel got jammed. Okay, and accident happened in which the two persons who asked for lift, they were injured. In this case, two passengers which were injured cannot ask for any remedy from the jeep driver because they asked for a lift, right? They voluntarily sat in his jeep. They asked for a lift. So maxim volenti non-fit injuria is applicable in this case. Case law number 3, Woolbridge versus Sumner. In this case, a horse race was going on, and you know how horses are, they go galloping. Okay, so horse race was going on, and a photographer, he was taking pictures of the horse race. While taking the pictures, he accidentally fall on the track of the horses. Okay, so one of the horse, he was galloping and the photographer got injured because of the horse. In this case, photographer had an idea that while taking photos, he might meet with some injury, and over here he cannot sue the horse race company for the injury, and volenti non-fit injuria is very well applicable in this case. Next case law is Smith versus Baker. There was a stone mine, okay, and A was an employee of B. So A was working on the stones, he was hammering the stones, and the crane was carrying some stones, and due to negligent act of the crane worker, some stones, they fell on A and A got injured. In this case, he sued B for the damages. Court provided that over here, he signed for the injury, but he didn't sign for the negligent act of the defendant company, and hence volenti non-fit injuria is not applicable over here because workers are protected under workers' laws like Workmen's Compensation Act, and defendant is under a liability to pay plaintiff. Next case law is Haynes versus Hardwood. In this case, defendant he had a horse company, and his servant was taking two horses to a city. While taking horses to a city, there was a police chowki or police station, and he tied those horses near the police station and he went to have his lunch. Meanwhile, the horses, they got scared by the kids playing around, and then they started going here and there. One police officer who was a plaintiff came out of the police station and he tried to catch those horses, and while doing so he got injured. He did it voluntarily, but the court provided that it was a duty of a defendant to take due care in this case, and though police officer did this voluntarily, okay, defendant is liable over here for his negligent act, and he is liable to pay compensation to plaintiff who is a police officer. Last case law is Slater versus Clay Cross Company Limited. In this case, what happened? Plaintiff was walking in a tunnel of a railway company, and a railway came and he got injured because of the railway. In this case, there was a rule that driver of the railway, he has to blow a whistle in tunnel, but he didn't do that. So in this case, this maxim volenti non-fit injuria is not applicable, and defendant is under a duty to pay plaintiff. After providing all these case laws, conclude that what is the meaning of volenti non-fit injuria? It has its origin in common law. This is a Latin maxim. It has origin in Roman law, again, which is a part of Europe. Okay, so provide everything about this. What is the meaning of volenti non fit injuria? And this maxim is applicable in Indian law because we still follow the common law legal system. And then conclude. One of my students, her name is Dwarka Mai. She requested for this lecture, and that's why I delivered this lecture for her and for you all. So if you need any more lecture on any other topic, on law of torts or any other law subjects, please provide your name and mention the topic which you want me to cover in my next lecture. Till then, goodbye and good luck.